Welcome to the People's Law School. I'm Herb Santos Jr. The People's Law School has been helping Nevadans understand their rights and responsibilities under the law for over 25 years. And by joining us today, you are taking part in a Nevada tradition. Our hope is that you will come away from this program with a greater understanding of Nevada and federal law, how these laws affect and protect you, what issues you can deal with on your own, and when it would make sense to hire an attorney. It is now my pleasure to introduce the speaker for today's show, Marjorie Hoff. Marjorie Hoff is a Martindale-Hubbell AV-rated attorney with over 10 years' experience protecting injured people. Marjorie obtained her Bachelor of Arts at the University of Nevada, Las Vegas, cum laude, and law degree from the William S. Boyd School of Law charter class in 2002. While she was there, she received the prestigious Cali Award for Law Practice Management. Prior to admission to the Nevada Bar, she worked in hotel casino management in Las Vegas. Her presentation today is one that every Nevadan needs to hear: wills, trusts, and probate. She'll cover the best course of action based on your income, wealth, and property, the common misconceptions surrounding wills, and how you can protect your family and your legacy by taking action now.
Let me start out by sort of an overview. Let's talk about what is an estate. Essentially, it's everything that you own: your house, your property, your bank accounts, your investments, your retirement benefits, your 401k, your IRA, your insurance policies, your life insurance policies, and of course, your personal property like your collectibles, your furniture, all of those items. There are different ways that you can deal with how to transfer all of those items upon your death. You want to be able to control who receives your assets after you pass away. You want to be able to minimize the legal fees and taxes that your loved ones are going to be responsible to pay following your death, and you want to make sure that you're maximizing those benefits even while you're still alive. Estate planning is for more than just when you die. It protects you if you're incapacitated. It protects you if you're unable to make your own decisions about your medical care. It's not something you should just look at when you get older. As we get older, we tend to start thinking more about how we're going to transfer our assets when we die. But even when you're younger and have a young family, sometimes in those instances, it's even more important that you have estate planning in place. And this is largely because if you have a young family, you have small children that you're going to have to provide for, both financially and somebody to take care of them in the event that something happens to you earlier than you expect in your life. So who needs estate planning? Single people, whether you're young or old, need to plan. Families need to plan. Older people need to plan. Estate planning is important for everybody, from the wealthiest to lower income individuals. You still want to be able to control your own destiny of your money and your own destiny of what happens to you in the event that you're incapacitated. When should you begin your estate plan? There is no time like the present. Just like many other things in life, I see it time and time again in my practice where people come in for a consultation and say, I want to talk about what my options are and what I should do to take care of my property and my children and my family. And we have that consultation and we talk about what their options are, much like we're going to go to today. We give them a packet of information to fill out to provide us with all the details that we need to put in that estate plan, and then we never see them again. We never hear back from them. It is not something that you should take lightly, and it's not something you should can put off doing, because I'm sure we all have an example in our life of something that you wish you would have done, or somebody that you wish would have done it before it was too late. Nobody likes to think about their own mortality. Nobody likes to think about becoming incapacitated, but unfortunately it happens, and it makes more sense to take care of it proactively rather than reactively and protect the people that you love. There are 6 basic estate plans. Number 1 is a simple will. Number 2 is the always ever-present option to do nothing. There's a plan that would include putting all of your assets into a joint ownership situation. There's gifting. giving away your property while you're still alive. There's beneficiary transfers, which covers things like retirement accounts, insurance policies, where you name a beneficiary. And then, of course, there's a complete estate plan package that would include your will, your revocable living trust, your and your durable powers of attorney with regards to health care and finances. We'll talk about each of these different options in turn. The first option is a simple will. Essentially, a will is a short and relatively easy document to prepare. It talks about who's going to handle your final affairs, who's going to receive your assets after you die, but it will only control assets that are titled in your name. It won't control, for example, joint ownership assets. It won't control assets with beneficiary designations like your life insurance policy or your 401k. It does not give you control over all of your assets. Who will have control over your assets in a will situation, although it'll spell out your desires, is going to be the court through the probate process. The probate process is simply a legal process where the court will first validate or invalidate your will. In other words, the court will review your will and make sure that it meets all the criteria that are necessary for a valid will. It will establish an order by which your debts are paid that are remaining after your death. It will establish an order by which your assets are distributed, and that will usually be according to the provisions of the will, if they're complete. Essentially, at the end of the day, probate is the only way to change the title in those assets to a new owner. If you're no longer living, you can't sign over your car to your son. You know, that has to be done through some sort of order of the court, and they give you the opportunity to do that. Friends and family can't transfer those assets without the court approval, so you have to go through the probate process when you're dealing with a will. Most of the assets that are titled in your name must go through the probate process so that the titles can be changed and distributed according to the terms of your will. The biggest concern of most people is obviously the probate taxes. There are taxes associated with the probate process. So those are some of the pitfalls. It's costly, the attorney's fees will be expensive, hundreds of millions of dollars going to bonding companies, appraisers, and the probate courts to determine the value of the assets that are being probated and how much the estate is worth, therefore how much the estate is going to be taxed. And all of those costs come out of the estate. It's going to be a separate court proceeding in every state where you own property. So if you have property in Nevada where your house is, but you have a vacation home in San Diego, you're going to have to open a probate process both in California and Nevada. Sometimes it can be several months to years before, in a larger estate, before that estate is closed. Another interesting thing with regards to probate is it's public. Now, for some of us who have relatively minimal estates, we own a house, we own a car, we have some money in the bank, that may not be as concerning, but if you have a large estate, all of your financial information becomes public. And there's no way to restrict that. Probate is a public, open process, and everybody's going to get to know what you've owned, including your disgruntled relatives who you wrote out of your will. It invites solicitors to come in and solicit the remaining parties about trying to manage some of those assets. And again, the probate court, not your family or your friends or who you want, your financial advisor has control over the estate. The court's going to determine whether or not the will is valid, how the will is to be interpreted, and how long it will take to finalize the process, and what information gets to be made to the public, which is generally everything. A will does not address your incapacity at all. So a will will not utilize what I call your pull the plug provisions, whether or not you want the plug pulled if you're incapacitated. A will doesn't cover that. It only comes into effect after you die. The court has to get involved if you become incapacitated, adjudicate your incapacity or determine that you're incapacitated, and appoint the person that's going to handle those decisions, which may or may not be the person that you would pick. It does not cover what a durable power of attorney covers. So if we compare those things here, a durable power of attorney You'd have a separate one in a complete estate package, one for your financial affairs and one for your health affairs or your medical affairs. And it allows you to identify who will handle those affairs if you become incapacitated. And there's generally not going to be any litigation or attorney's fees associated with that because it's a document that you proactively established while you had the ability to do that, and there's no reason for it to be contested. It becomes effective when you're determined to be incapacitated by a medical professional and doesn't necessarily require a court process, and it's private. One thing that a will does do for you is it does lay out your guardianship information. This is something that's done in a will, and a will, even if you do a complete estate package with a living trust and a durable power of attorney and all the other items that are included, you still will have a will. And it'll include, and we'll talk about it a little more in a minute, it's called a pour-over will. So essentially anything you forgot to transfer into the name of the trust, that will then be probated and put into the trust. The will says, anything I forgot, put it into the trust. But it's also going to be where your guardianship provisions are. So a court will not be the one to name the guardian of the children in your will, and it will also not be the one to control the money that you leave to minor children. But a will combined with a living trust is going to allow you to control both the the guardianship provisions as well as the inheritance provisions. In other words, who's going to control that money? The court won't be the one to control your children's money. The second option, obviously, is do nothing. The court will distribute your assets. The court will pay your creditors. The court will determine who takes what from your estate. You don't get any say in the process. The state may get all of your assets in the event you're an individual who doesn't have any easily identifiable heirs. People with living parents or living children or living siblings that they maintain relationships with, those are going to be easily identifiable heirs if you die intestate. Unfortunately, if you're older or don't have any of those, maintain those close family relationships where the people, and unfortunately we see it, where the people around you are not knowledgeable about what you want, or even in some cases that you've passed away, all of your assets are going to go to the state. If you're incapacitated and you have no estate planning in place, the court is going to control your assets, pay your debts by court order, and appoint someone to manage your affairs, usually a public guardian, who has no idea who you are or what you want. The third plan, and this is something that people commonly do, and it's not a bad option, but it's not the best option, and we'll talk about a little bit down the line here why that is. The most common form of is to title your assets in joint tenancy with a right of survivorship. What that means is that if me and my husband own our house as joint tenants with a right of survivorship, and I pass away, he's the surviving owner and he has full ownership of the asset. It avoids probate, but does it give you the control you want? It may give you the immediate control you want, but long term, it doesn't. Let's say we have Sue and Tom own everything in joint tenancy. Tom passes away, Sue gets everything. That's what Tom wanted. He wanted his wife to have everything. But what happens now when Sue dies? The assets at that point do get probated, and only Sue's heirs will inherit, not Tom's heirs. So if Tom had parents or a favorite cousin or somebody that he wanted to leave something to, it only is going to go to Sue's heirs. If Tom had children that were not Sue's, they're now cut out in a joint ownership situation. It doesn't avoid probate, it just postpones it until the second person passes away. And it doesn't account for the situation of what if this unfortunately happens in a young couple, and what if Sue doesn't die soon after Tom? What if Sue goes on living and gets remarried and has other children? Let's look at that situation. If Sue then marries John, and then Sue dies, now John owns everything, right? John owns everything that was Tom and Sue's. Now neither Tom or Sue's heirs get any of their assets. And John's under no legal obligation to give anything to Sue or Tom's heirs. Even if she had put it in her will, even if she had a will and she had put it in her will that she wanted a portion of the estate to go to her children, it wouldn't matter if the assets were titled in a joint tenancy with a right of survivorship, because that is not going to that is going to transfer the entire asset at the time of her death, regardless of what it says in her will. So wills are not going to control that property that's in joint tenancy. Nothing is going to control it. As soon as you pass away, it transfers as you wanted it to one time, but after that, it's completely out of your control. That person that has it can sell it, they can transfer it to somebody else, or they can unintentionally end up disinheriting your own children, as it would in a situation like this. The fourth option is gifting away your assets. That's transferring the property while you're alive to the people that you want to have it. That is something that parents will often do with their adult children, that they want to have their things if they pass away. If the main downfall to that, obviously, is what if you need the asset later? I've recently encountered a situation where this was an estate plan for a gentleman who's now in his 80s. He had just gifted away what he had wanted to his respective children, or put them on, like, his bank accounts, his safety deposit box, and things like that as joint tenancy. One of his children decided that she didn't think he was spending his money properly and emptied out his account. And there's nothing he can do about it. He doesn't have any, he had chosen to put her on as a joint person on that account, and she had the opportunity. He'd given her the right to do that, and there's no way he can now control that asset. Another unintended pitfall is gifting gives you a stepped-up basis. Let me explain to you a little bit about what that means. The recipient of the gift can incur a tax problem in the event the asset is gifted during their lifetime. So let me give you an example. Let's say that Bill, who's a dad, bought his home back in 1935 and paid $20,000 for it. And today it's worth $250,000. He gives it to his son, who then, after he gives it to his son, and Bill lives there through the remainder of his life, but when Bill passes away, Bob decides he wants to sell it. And he's going to sell it for the value of the house, for the $250,000. Since the title transferred during Bill's life, during the dad's life, the house retains the old cost basis of the $20,000. So what happens now, Bob, the son, has to pay tax on the $230 as capital gains. What would have happened if Bill had left his home to Bob as an inheritance, either through a will or a trust instead? He sells the same house for $250,000 after the death of the father, and the father would have been able to, Bill would have been able to retain the house, live in the house, and control it if it was in a trust, and then it would pass upon his death. But since it didn't pass till he died, since the title didn't pass till he died, the value receives a stepped-up basis. The value of the house is now automatically on the books, so to speak, $250,000. So there's no capital gains if he decides to sell the house at that point. However, if you have a larger estate, and you can afford to give away some of those assets during your life in a $1 million estate or a multi-million-dollar estate, sometimes that's a good way to actually reduce the estate taxes. The estate taxes, which we'll talk about in a minute, are much higher. On a large estate, your estate taxes are going to be 40%, and the capital gain may be less. So you may decide that you want to gift those because the tax ramifications will be less than it would be to the estate. However, that's a pretty high number that is going to be hit with those kinds of taxes. The fifth type of estate planning is beneficiary transfers. Those are types of assets that automatically transfer to a beneficiary. And you've all done this when you fill out a life insurance policy or a retirement account, or even sometimes on your bank accounts, they'll ask for a pay on death designation or a beneficiary designation. And those things will automatically transfer to the beneficiary upon your death. However, you need to make sure you stay on top of that, because if something has happened to the beneficiary or they've passed away, you're now back to square one where you have no beneficiary and you have to go through the probate process. If you list my estate as the beneficiary, which some people are advised to do, again, that gets probated to determine who is your estate. If you list a minor as the beneficiary, now the court gets to control that asset until the minor becomes an adult. The plan that I generally recommend is going to be a complete estate planning package, and this is going to be the best choice for most people. It's going to include a revocable living trust. It's going to talk about where you want most of your things to go. A certificate of trust, which is how you prove to people that you have a trust and you want to transfer assets into the name of the trust. It will include a pour-over will, which we talked about a little bit, that'll say, hey, anything I forgot to put in this trust needs to go into the trust and be controlled by the trust. And your powers of attorney for health care, your living will, which is what I call your pull-the-plug provisions, your springing power of attorney, which will be your financial means, which will talk about your financial means and who controls those, and anatomical gift designations, like if you want to donate organs. What are the benefits of doing a trust, a revocable living trust, versus a will or these other 5 estate planning options that we talked about? Number one, it transfers your assets before your death. You're going to transfer all of your assets into the name of the trust. Your bank accounts, your house, any other property that you own, your car, you can transfer all of that into your trust. It allows you to keep control over your assets while you're alive, and it controls the distribution of the assets as well after you die. Instead of you owning your assets, the assets are owned by your trust, of which you are the trustee. So you're still controlling your assets as a trustee, but once you pass away, your successor trustee comes in, the person you named to take over as trustee after you die, and they have an obligation at that point to control your assets according to what's outlined in that document. So you still maintain control. It's revocable and amendable at any time before you die. It avoids probates of assets in the trust. You still will have to probate the pour-over assets, whatever you forgot to put in the trust. Those will still have to be probated, but it's a simple probate process because you have a trust. And all that's going to say is transfer it to the trust, you get the order, you transfer it in. It reduces the estate taxes that we were talking about a little bit by maximizing your tax exemptions. So as of 2013, you do not get probate taxes assessed against your estate if your estate is worth less than $5 million. And that's now, as of 2013, a permanent cap. There was a point in time where it sort of went, where it was on a sliding scale where it went up and then came back down again, but now it's permanently set at $5 million with an index for inflation. So for this year, 2014, if you die with an estate worth less than $2.34 million, you will not be assessed any probate taxes. If you live in a state that has state probate taxes, this is only federal that we're talking about. If you live in a state that has state probate taxes, you're still going to be subject to those, and those have different caps. Every state has different caps. So you have to look at that in your particular state. But federally, it's $5.34 million, and then 40% on any assets in the estate above $5.34 million. So if you have a $6 million estate, roughly $70,000 of that is going to get hit at a 40% tax rate. This just sort of outlines an overview of some of the things we talked about with regards to the difference between a will and a trust, as far as when those assets transfer, what the costs and fees are, the length of time. It's obviously something, it's a lot quicker with a living trust than a will. You maintain more flexibility and control in the privacy concerns. Obviously, a trust is private. It's not a document you have to file. So that sort of outlines some of the differences there. Just to sort of recap here, you control the inheritance. The trust doesn't die with you. The assets are still owned by the trust, and they have to be distributed according to, or handled according to, the rules in the trust. You can set it up any way you want. You can set up any sort of provisions that you want. You don't have a situation where those assets have to transfer immediately. You can transfer them in staggering amounts. You can have, for example, I've set up my own trust in a way where my children will receive a certain percentage of their inheritance at certain ages, because I don't want an 18-year-old to have a lot of money. And you don't want an 18-year-old to have control of their college fund. So the assets can stay in the trust until you want the beneficiaries to receive them. You can put contingencies. You can put contingencies on an inheritance that, for example, says this child only gets X, Y, or Z if they go to college. And that's completely fine, and that's your control. You maintain that control. You're not going to maintain that kind of control with any other estate planning option. You can also provide periodic income, like we talked about, where they receive certain amounts at certain times or things for certain items. Once you get your estate planning in place, you're going to have the vehicles in place to be able to do that. You know your assets are going to do what you want to do after you pass away, and you can relax knowing that those kinds of things are going to be taken care of. Thanks.
Thank you for watching the People's Law School. Be sure to tune in next time as we cover the issues related to the filing of bankruptcy in the state of Nevada.